football coach at a local high school. He is a former NFL player, and he is giving his talents and giving back to the community.
All right, why are you threatening to send out videos? Like why? And why were you knocking on her door or knocking on her window? What were you expecting? So you're going to have to do better. Otherwise, you're going to shorten your life significantly. I don't want to hear about you on the news. Right. You know,
Faithful was moved out of the house in April of 22, not 23. You all got the wrong dates. I don't know why.
He doesn't, ma'am, I don't need that.
Okay.
Well, does Miss Bell still need the dog? And
So-
that's when we,
Whoa, whoa. No. I'm just trying to sort this out. Because this doesn't make much sense to me.
you're charged with the offense of publishing or threatening to publish intimate visual material as a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand? All right, after reviewing state's exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
Yes, Your Honor.
Yes, Your Honor, we'll waive PSI.
All right, anything you wish to say on behalf of your client?
Yes, Your Honor. So this, the offense as charged, right? Whenever you see that offense on paper, you know, it gives a certain impression. Our client was in the throes of custody issues. He understands that he made the wrong decision to take his anger out in that way, rather than, you know, addressing it in a healthy manner. Mr. Carter volunteers as a football coach at a local high school. He is a former NFL player, and he is giving his talents and giving back to the community in that way. He is fully committed to continuing that path. He is fully committed to working on himself, and this incident does not define him. He is remorseful, and he's ready to change under your supervision.
All right, why is there a request for BIPP? I'm
That-
sorry, you're not the attorney on this, but I mean, I understand that this is seen as a form of abuse, but isn't BIPP for physical?
Battery.
Yes, Judge, and I can just imagine, because it's someone who was a spouse of his, and someone, this is not just some random person, and so
I mean, I'm not gonna order that. How old are you?
46.
All right, why are you threatening to send out videos?
I made a mistake.
No, you didn't make a mistake. You made a choice.
I made a choice. I made a bad choice. Didn't think why.
Like why? And why were you knocking on her door or knocking on her window? What were you expecting?
Talk about my daughter, but it didn't help at all.
Well, what time did you go to talk about your daughter? What time was it? What does late mean?
Past a bit time, 10 o'clock, I think. Well,
All right, nobody's knocking on somebody's door at 10 p.m. to talk about their daughter or talk about their child. They're usually there for something else. Did you call her? And I see you called her and she blocked you.
this one.
All right, so it appears that she doesn't want you anymore. I don't know why people can't accept that. And it's not like you're a teenager. Even teenagers, when somebody doesn't want you anymore, you can move on. As my grandmother would say, cry on the inside. Don't let that person know they've broken your heart, and just move on.
This one.
I don't understand why you don't understand that.
If I may, I think context matters here.
Oh,
My
yes.
understanding is that the complaining witness was withholding visitation from my client, and he had no way to do it. A custody suit has ensued, and they're working that out. But during that time, they were breaking up.
So why would he go over her house after 10? Why not go over there at lunchtime? Why not go over there during, daylight time?
I think he was frantic, Your Honor. And he understands, right?
I want to find out if he was frantic. He hasn't told me anything.
I just reacted the wrong way.
No, but I mean, why go to her place at 10? And the reason why I'm asking you these questions, it's so I can determine whether or not all of these extra conditions that the state is asking, whether or not that's appropriate.
Because at the time I was allowed to come over there anytime I was so serious, and I thought we could just go over there.
What do you mean you were allowed to come over at any time?
No, because I used to go over there like to see my daughter. I leave to go home by 8 before she go put in bed. Then all of a sudden, then she got mad at me, and then she blocked me, and I was just talking to her, and I just went over there, and I should have went over there.
Mhm.
That's when the custody thing came up in after the fact. So
So what family members do you have in San Antonio?
you know, I moved out here just for my daughter,
To co-parents
for co-parent.
from Alabama.
We was trying to get together. I bought a house here, and we're not together, so I'm stuck in San Antonio. So I said, and I only got here about my daughter here. That's it. I don't have no family.
So how do you all discuss childcare issues? What is happening with that?
Uh,
Is it through the app?
right now we've been talking to each other on the phone, and my daughter got a watch, and I've been hanging out with her when she allowed me to see her. Taking me to eat. Supposed to be going to see the light show tonight. So that's what I've been contacting.
With the complainant and the daughter.
Right.
So they're amicable.
Within both of us.
Well, here's the thing. People hang out with each other and then they think things are great. And then maybe they'll decide that they're going to get back together. You shouldn't do that because whatever issues y'all had previously, these same issues are there.
Judge, he also has a daughter that's 17 that is in the state championship as a wrestler in Alabama. She's already not committed, but she's been offered a full ride to the Naval Academy. So we'd ask that he be able to travel freely between Alabama and I guess Annapolis, right? Should that be where she commits?
All right. So what I can tell parties, I don't know why people get in relationships and then they have this issue with the children where people are not letting people see each other, not letting people see their children. But this is what I can tell you. When a relationship is over, it's over. Don't try to get back in that relationship. You and the complainant are supposed to be adults and everybody's supposed to be putting their children first.
Yes, ma'am.
And when people hurt the mother of their child, the father of their child, just being petty, then you're hurting the child. Do you understand?
Yes, ma'am. I understand.
And I can tell you, until things were explained to me, I was close to giving you jail time as a condition. But now I'm able to see everything and the state was not asking for jail time as a condition.
Judge, again, context, complaining witness and my client went to the same school, Troy University, Alabama. And he played football for the school and she was an athletic trainer, correct?
Yeah, I've been on a lot.
So it's an on and off relationship for 20 some odd years. Is that right? 6 years.
It's been a while.
Then the baby came along and tried to do the right thing, moved to Texas to co-parent and things happen.
All righty. This is what the court is going to do. Court is going to sentence you to 2 years deferred adjudication. There's to be regular reporting by Zoom or in person, regular random UAs, proof of employment within 45 days. There's to be no employment as a home health care provider or with minors. The coaching that you do, are you paid for that?
No, ma'am.
Okay, so.
I don't get paid for it.
All right, so there's to be no there's to be no employment as a home health care provider with minors. There's to be 100 hours of community service restitution. Ms. Abrams, if you verify that he's actually coaching, that can count towards his community service hours. Field visits 1 time per month for 3 months. And the complainant is requesting the no harmful or injurious contact.
Yes, Judge, and the idea is for the child custody and transferring.
All right,
Good.
there's, yes.
He has total and permanent disability with the NFL. And so he's not allowed to work for that.
He'll need to provide proof of that.
Okay.
All right, so proof of employment within 40 days or proof of inability to work. All right. Is there anything else that you need from the court to be successful? All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, ma'am.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
All right, if you complete everything early, the court will consider early termination.
And Judge, I may have not on it, but did you allow travel?
Ms. Abrams? He's allowed to travel to
Alabama?
events with his other daughter. So he's allowed to travel to out of state. Because maybe they're gonna go to another wrestling tournament other than Alabama.
And is that just particularly to his daughter, Your Honor, or can it be
Yes.
also, he has an elderly mother because that lives in Alabama, he helps care for, he's the only child that can care for her.
All right, you all will just need to approach on that. Your attorneys will need to turn that over to probation.
Thank you.
Okay.
Okay. Thank you.
All right, Vashawn, just go ahead and say he's allowed to travel out of state for his child and also for his mother. And there's to be UA upon return. So that'll be a UA within 24 hours. So if you leave and you come back, it'll be the UA the next business day. And you can either do UAs or either you can do the patch. The patch costs more, but with the patch, probation will just put a patch on you. You don't take it off, don't tamper with it because that'll be a violation of your probation. They will pull it off and then they'll test it. All right, did you review the trial court did you review the trial court certification of defendant's rights to appeal with your attorney? Did you understand it and sign it?
Yes, ma'am.
All right, because this plea bargain agreement, because I followed your plea bargain agreement and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
All right, we're off the records. They're saying they have a victim impact. Basically, what ends up happening is the complainant speaks to you. I require that everyone is respectful to each other, and usually the complainant will tell you their feelings on this offense. Do you understand?
Yes, ma'am.
Great, thank you. So if you'll stand over there and the complainant,
So we're asking the court just go ahead and honor the agreement of the parties just place on trial.
all right. So why are you homeless?
Marital issues and where I was at, we caught a charge, an assault charge in our marriage, but where I was at, I wasn't on the lease. And so with that, I guess disturbance of where we were at, because it was a house with rooms rented out, there were other tenants and it was disruptive. So I mean, I could have stayed, but I would have been going against his terms. I would have been going against my own terms as far as us not being able to be together at that time.
How old are you?
I'm 30. I just turned 30 in Fort.
Where's your family?
I have family in Fort Worth. I have my aunt here and my stepdad here, but because I do have a history of drinking, I don't really have anywhere stable to be at without them trusting that I won't drink.
All right, do you have any children?
I have stepchildren in my marriage.
All right, what's your mental health diagnosis?
I have schizoaffective depressed type and manic depression with psychosis.
Other than alcohol, what have you used?
I have smoked weed, mags, I've done meth. Meth is my go-to on the streets, as far as being on the streets. That's why I do need shelter. I need some. I know I've been in Haven for Hope and they've helped. It's just I wasn't ready. You know what I mean? But that is one place that I would like to go back into. I was in the jail outreach program there. So it's kind of like you report there too.
When's the last time you had employment?
It's been years.
All right, so how are you supporting yourself?
I'm on the streets, I panhandle.
What's your criminal history?
Lately it's been criminal trespass because with me being homeless, I try not to move around too much. So I generally just stay in that area just because it's safe for me.
All right, so what is her criminal history? Does anyone know?
She has just a misdemeanor history, Judge. This is her first felony offense. That's why they were recommending defer. Yeah, she's been incarcerated the whole time since she was picked up on this charge.
And Your Honor, as far as I can tell, it is just misdemeanor history.
Yes, ma'am. This is my first felony.
Yeah, there was a felony that was reduced to a misdemeanor, but
Okay, any violent history?
it was an assault.
Yes, ma'am.
What is your violent history?
I do have a previous, it was an aggravated assault with a deadly weapon dropped down to an assault, and then I have two other assaults, one in Tarrant County, I believe it was, Cold Spring, and another one here.
Are they misdemeanors?
Yes, ma'am. They're all misdemeanors.
I appreciate your honesty. All right, this is what the court is going to do. 4 years deferred adjudication, $500 fine to probated. Take in consideration 2022 CR 6751. There's to be no contact with the Quick Trip Store, number 4007 at 310 San Pedro. Felony Drug Court is a great program. It's one-stop shopping. They'll take care of mental health issues. They'll take care of drug issues. They'll take care of housing issue. They'll take care of employment issues as far as getting you on track with your life. So you need to be as honest with them as you've been with me, and they'll accept you. All right. There is going to be field visits 2 times per month. And the conditions I'm giving you, if you're accepted to felony drug court, they're going to be in charge of the conditions. So they may do something different than what I've done.
Okay.
Once you go to felony drug court, I'll only see you for 2 reasons. 1, you've graduated and you want to tell me, thank you so much for sending me there. I got my life in order and I'm in touch with my family again. Or 2, they bring you back here because they say, we tried, she didn't want it. All right, there's to be regular reporting by Zoom or in person within 15 days. There's to be no employment as a home health care provider with minors. There's to be no unsupervised contact with minors until further notice. And so what that means is your husband, whoever it is, if the children are with you all and he needs to do a grocery store run, you need to tell him you're gonna have to take the children with you because I'm not allowed to be around the children by myself. You understand? Probation, is there anything else that she needs?
No, Judge.
All right, is there anything else that you need from the court in order to be successful?
I noticed you said 15 days of employment. I do not have any type of ID, like no ID, no social.
Oh, they're gonna take care of that.
Okay, I
All
just
right.
wanted you to know that personally. So if they can be like, she don't have a job by 15, at least you know that.
Oh, well, here's the thing. This is what I require. I require that people are to make sure that they are seeking employment. So if people don't have employment, you got to show proof that you've been out there hustling, trying to get employment. Oh, and also probation, I'm going to want a MIC evaluation as well.
Is that, well, see, that's, I thought it was DDR. But
Yeah, DDR, MIC.
is that gonna come after the drug court evaluation? Or?
Yes, after. So I'm at 1, felony drug court, 2, MIC DDRF.
Okay.
And she's gonna remain in custody until those are done.
Yes, ma'am.
So today is Monday, last time I checked. If this is sent to felony drug court today, they'll probably see you this week or at the latest next week on Monday.
Okay.
Be completely honest with them, okay? All right, is there anything from either side with regards to sentencing? Anything else?
Nothing pro tem defense, Judge. The approval of the dismiss.
All right, thank you. Show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it and did you sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand? All right, is there anything else?
Nothing from the defense, Judge.
All right, we can go off the record. Ms. Smith,
Yes, ma'am.
you're gonna have to change your ways. I always tell everybody that I'm in the twilight of my life. They tell me I'm not, but really I have more of my life behind me than in front of me, right? We deduct from our life on this planet when we do bad things, right, to our bodies, not exercising. That may take a couple of years off your life. Not eating right, that may take a couple of years, maybe just 1 year off your life, right? But if you're out there using drugs, that takes a lot of time off on your life and it ages you. And the fact that you don't know what people are putting in the drugs because it's not FDA approved. Like there's a rat running around, pooping on the drugs. People like, well, let's just put it in there because they're not going to throw it away and say a rat got in this. You never hear on the news about people who make drugs that they won the blue plate special award because they don't care, right? So you're going to have to do better. Otherwise, you're going to shorten your life significantly. I don't want to hear about you on the news,
Right.
Dead from drug overdose.
Yes, ma'am.
Okay. All right. Good luck to you.
Thank you so much.
You're welcome.
Take care. Okay, well, any problems, let me know.
Okay.
Let's take that. Thank you.
Court is calling 2022 CR 6750 State of Texas versus Ayanna LaShawn Smith. Could I have parties and defense if you'll be on? Could I have parties announced for the record for the state?
Daniel Escobar for the state of Texas.
Melissa Christian for the defendant.
And I'm going to need everybody in the box to be quiet. We're on the record. And are you Ms. Smith?
Yes, ma'am.
All right, Ms. Smith, I'm going to show you what's entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision. Did you have a chance to review that with your attorney? Did you understand it?
Yes, ma'am.
Counsel, this motion was filed today. Of course, you're entitled to 10 days to prepare.
We waive.
All right. Ms. Smith, do you have any objections to your attorney waiving the 10 days? All right. Are you the same Ayanna Smith who was placed on deferred adjudication? All right. You all need to be quiet in the box. That's okay. Are you the same Ayanna LaShawn Smith who's placed on deferred adjudication in 2022 CR 6750 for the offense of taking a weapon from an officer on August 29, 2022 for a period of 4 years? Is that you?
Yes, ma'am.
All right, state.
Violated condition number 14 AA on or about the 10th day of November 2022 in Bexar County, Texas. The defendant, Ayanna LaShawn Smith, did then and there fail to complete the treatment alternatives to incarceration program through Bexar County CSCD as directed by the court in violation of condition number 14 AA.
All right, how do you plead to that? True or not true?
True.
All right, did you understand by pleading true to violation 14AA, the court could find it true, grant the motion, find you guilty, sentence you up to 10 years in prison and up to $10,000 fine?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation 14AA?
Yes, ma'am. True.
Court will find 14AA true. Is there an agreement?
No, Judge.
All right, state, what are you requesting?
Judge, we're requesting revocation.
All right,
Judge,
so are both of you requesting revocation?
actually, Judge, our first request is to revoke and reform. And Ms. Smith has 221 days in custody. She is homeless. Honestly, this is probably a probation she was not ever going to be able to successfully complete due to her situation. At this point, we're asking for her to get some kind of a time served judgment, which would probably require the court to reduce it to an assault. In the alternative, we're requesting that the court consider revoking and just giving her 2 years, in which case she has pretty much sufficient time in for her to be paroled. She probably will have to, and I've explained to her, she'd probably have to go to TDC to get a number, but she would probably be eligible for being immediately paroled.
All right, and I see that the indictment, this is a case where she attempted to take an officer's nightstick. Is that correct?
Yes, Your Honor.
All right, state, what are you requesting? You say revocation, but what time are you requesting?
We were just requesting 2 years, Your Honor, for minimum.
I'm sorry?
2 years, the minimum.
All right, the court will grant the motion, find you guilty, sentence you to 2 years in the prison, give you credit for any time served. All right, we can go off the record. Good luck to you.
Thank you.
You're welcome. Have a great day.
Yes, ma'am, you as well.
The balance owing is basically stemming from pet fees and a pet deposit for an animal that Ms. Bell had. The question that's presented is the application of ESA. Back in 2019, Ms. Bell applied for an ESA for a dog, I believe it was a pit bull. She had a letter from her doctor indicating the need for the support animal. And it was granted. At that point in time, she did not pay a pet fee or a pet deposit. Subsequently, I believe in February of 2023, she had to remove the support animal because it was a pit bull and it apparently had bitten one of the tenants. That was in February. She replaced the animal, and then in October of 23, we requested that she certify the new animal, which I believe is Pipe Chihuahua. And
Well, let me ask this, because what was, I remember the issue, but the certification for the animal, however one wants to put that. Well, let me put it this way. Does the complex certify the animal?
the complex asked that she read certification that she of her needs for the support animal, which in 2019 she did provide for us. We asked starting in October when she got the new animal, we asked that she recertify herself that she had a continuous need for that support animal.
Okay, and again, that I guess brings me to the next point. If nothing had happened with the pit bull, she wouldn't have had to recertify anything.
Well, we take the position that we could have asked her to certify, but we didn't. The fact that she had the replacement animal brought it to our attention as, does Ms. Bell still need a support animal? If so, we asked that she be recertified. We asked, and I have if I can present to the court, if I may approach Your Honor.
What are those?
This is a thread of emails between Group 5, Group 5's attorneys who was handling the case then, and Nikki Green from Fair Housing, talking about the pet situation. And Nikki Green basically said she was going to follow up with her doctor, I think Dr. McAvoy, to see if we can get the certification. According to our information, Dr. McAvoy refused to do the certification. We asked that she possibly.
But was that the
doctor.
previous doctor?
Hmm?
Okay,
sorry.
but here's my issue with this. When she did that in 2019, she's not certifying the animal.
Correct. She's certifying her need for an animal.
Right. So what would lead the complex to think that changed?
Well,
Because and the reason I'm asking that is because based upon at least what's been represented to the court, the only thing that happened is the removal of the animal.
that brought it to the attention of management that does she still need a support animal? And that's why we requested certification.
Why would that raise the issue?
Well, I believe there's a difference between an ESA and a service dog. A service dog, if you're blind or
Right.
handicapped, you apply for a service dog. That's a different type of certification. And at that point in time, if it's granted, basically it's for life. Support animal is different. It's like,
Well, what explains to the tenant that it's different? I mean, because you from what I'm hearing, and correct me if I'm wrong, in 2019 to 2020, in 2020, the dog is still there and she doesn't have to do anything. The dog just continues there. 2020, 20 to 21, same thing. 2021 to 2022, same thing. So I'm looking at a 3-year period where she has to do nothing. She has this dog.
We didn't
Then
raise
the-
that issue at that point in time, but
Why though? I mean, what makes not raising the issue at that time as opposed to raising it later on? What's the distinction
well,
if you're not certifying the animal?
I believe that in a situation that the complex has the right, and there's nothing in the law either way, that we have the right to certify, recertify, or we don't have the right to recertify. So it brought us to the attention, does Ms. Bell still need certification? And it's a simple process. All she had to do is go to the doctor.
But I get that that's the process that the landlord wants her to enter into.
Correct.
The problem that I'm having with this is why was the request made at that time as opposed to being made at every 6 months, every year, every whatever?
Well, the dog was, the pit bull was removed in February of 23. We waited 8 months. She got a new dog. We waited 8 months until October of 23 in order to give her some time to get the certification. At that point in time, we formally requested it, and that's when we started
Okay, but when
assessing.
did the new dog come in?
Excuse me.
When was the new dog?
I can tell you all of that real quick because my mother doesn't even really sure of it. Faithful was moved out of the house in April of 22, not 23.
Okay,
She got
that's
home
fine.
in December of 22. You all got the wrong dates. I don't know
It
why.
doesn't, ma'am, I don't need that.
Okay.
If the dog got removed February, April,
Mhm.
when did the new dog show up?
December of 22. December of 22.
Yeah, it was 8 months after the old dog was removed.
And then when was the request made for the new?
In October of 23,
So,
I believe.
so was that the first request for the
For
BS?
recertification, yes. In October of 23.
So why did that happen then?
Why? Because at that point in time, we reviewed our records and we said, well, does Miss Bell still need the dog? And
So-
that's when
Whoa. No. I'm just trying to sort this out. Because this doesn't make much sense to me. The pit bull gets removed February of April, whichever it is, of 2022. Right? The new animal comes in December of 2022. Right? And the request for this is effectively a year later, 10 months later.
correct.
By the landlord.
Yeah, I understand what this court is struggling with, but if you take a look at, comparable laws like workers' comp, not social security or disability insurance, they have the right to review the continuing disability every so often, every 6 months.
But you're not reviewing her disability.
Yeah, we're asking, by asking her for recertification, we're asking.
Where in the lease does it state you could do that? I mean,
It
because
doesn't.
That's the problem. The problem
We're dealing with also with the law, Your Honor. The law is unclear on it itself. The fair housing, as it pertains to ESA, and I checked into it. There's
Okay.
no,
I get that. I understand the complexities or absence thereof. What I'm looking at the circumstances of this. So one thing that's very clear to me is had the pit bull remained, there wouldn't have been a request.
maybe,
Well, there wasn't.
there wasn't,
Right?
yeah. But that's,
Pit bull gets removed, a new dog comes in, and when the new dog's there, there still is no request.
at that point in time, no. I think,
Then 10 months later, effectively, almost 11, really, I guess, depending on when in the month these things are occurring, 10 to 11 months later, there then is a request.
correct.
And I'm trying to figure out why was that request made?
It was brought to our attention that does Miss Bell still need a support animal?
Brought to your attention by whom?
It was brought to our attention in the review of the record. A review of the record when we found out that she had the new dog, we asked that she recertify herself as a need for that support animal. And it's a simple, I understand the court, but it's a simple process. And according to the.
But why would you ask? That's my question. I'm not so much concerned about what the process is. I'm not concerned about what happened, didn't happen. Why would you ask?
It was a review of the records showing that she has a support animal. Does she need a support animal?
But hold on a second. When was the landlord aware of the new animal?
This is Kurt Herbeck. He's the.
When was, I just need an answer.
October.
October of what?
That's when she was first charged,
No, I'm not saying a charge. When does the landlord know she has this new animal?
I think it was sometime in 2023, according to the email threads I'm looking at. It was prior to.
It was several months after she removed the pit bull. She was observed with the Chihuahua, and that's when she was asked about it. She never came to.
That was 11 months after.
Yeah, but we didn't know that she had the Chihuahua at that point in time.
Is there a policy regarding this at all with the landlord?
Is there a policy
A written policy? What places the tenant on notice that this has to happen?
We
Or
notify them.
Or you can't do that, Mr. Weiss. She's under lease.
I understand. The pet agreement. There's nothing in the pet agreement that references it, but it also doesn't reference ESAs in the pet agreement. So ESA is a part of the fair housing.
Right.
Okay. There's nothing in the fair housing. I understand.
I'm trying to figure out what triggers the landlord to ask. And with that, what places the tenant on notice that the landlord can ask and then needs to comply with something?
Well, they have to inform us that they have a pet. Okay. If they're claiming that they have a need to have that pet classified as an ESA, emotional support animal, they have to go through the procedures as set forth.
Okay, but that's apples and oranges.
No, I don't think so.
Well, it is because she's not here because she failed to notify you of the dog.
No, she's here because
She's here, at least what the landlord's saying is because the landlord made a request for the doctor to indicate that she needed an ESA.
the continued need.
And what gives the landlord the right to ask her that once she has already given it? Under what authority is the landlord requesting that?
Well, as I said, the ESA has no law either way. As far as
Either way,
requiring
in terms of what?
of requiring recertification or not.
Here's the landlord's problem.
I know what the landlord's
Yeah.
problem is.
If the landlord said, okay, every year, for those that have an ESA, every year you must recertify the need. Fine. Even if then there's a late request, the landlord has something to say, I can make this request. So the time period doesn't necessarily matter. But as I'm looking at this from what I'm hearing is had the pit bull still been there, there would have been no request from the landlord to do anything.
Maybe.
Well, it's not a maybe. For the 3 years, 19, 20, 21, and 22, 4 years almost, that the pit bull is there, there's been only one request or one submission. They didn't ask each year.
No, but what
There's not even anything, Mr. Weiss, unless you can point me to something that says, okay, periodically we will request X. Is there anything that says that would place the tenant on notice that the landlord could make the request?
not that I am aware of right now, but if I can point the court before it makes a ruling, take a look at the email threads from Fair Housing and from Group 5 and Group 5's attorneys.
But what are those email threads going to do for me?
It would show that this was discussed. It was discussed with Ms. Bell.
Okay, I get it. I get all of that's discussed. And if necessary, I would take a look at it. What gives the landlord the right to do it in the first place? What gives the landlord the right to say anything that makes that discussion happen? Mr. Weiss, you can turn my question around all you want.
I know.
But it doesn't get you anywhere.
I used to be very good at that. You know that.
I know. And I expected that's what I'd get as an answer, but that's not an answer. I mean, here's the tenant who's saying, look, I have this ESA. I have this dog. Something happens with my dog. Let's say the dog didn't have to be removed from vet, but let's say the dog passes away. She gets a new dog. Would the landlord ask then for that? But they didn't, even in this case.
Not for a year later.
And then the question becomes, why did they ask a year later? Second thing is, under what authority did they ask that could affect this tenant's tenancy?
Well, as Mr. Herbeck had indicated, we didn't know about the dog, the Chihuahua, until long after she got it. It was seen.
But you're not certifying the dog.
I understand that.
If I get if you were certifying the dog and it was the status of the dog that grants that authority or that position of the tenant, I get that then. But you're not doing that. You're not even, what you're doing is you're certifying, or essence, asking for certification from the tenant. So at what point, and obviously there is nothing in writing, at what point does that expire? At what point does is the tenant obligated to do anything?
Let me pose an absurd situation.
Besides this one?
Yes.
Okay, go ahead.
Let's say the pit bull is removed and she decides to get a cow instead of a dog.
Okay.
Don't we have the right to question that as an ESA? Or do we? It's an absurd question. I can go hire an elephant or whatever. But we do have a right to review that situation.
I think you might have some justification if somebody had a dog and now has a cow. Or if they have a dog and then they get a tiger. I mean, I get that. But all I have, because at that point, though, your issue, the cow, and I'm not into answering hypotheticals, but your issue becomes that animal on our premises.
In part, yes.
Well, no, that's going to be, if it's a cow, I hope that's really your major concern.
Yes.
But in this case, it's a dog. And so it's not the issue of there being a dog. It's the issue of whether she needs an emotional support animal. But she's already answered the question, and the landlord doesn't have a procedure upon which they can make the request. Because the cold-hearted reality is, because of fair housing and other things, I'm telling you, Mr. Weiss, your client's going to be without a structure to it.
Without a what?
Without a structure to when they make the request or require the tenant to do something, they're placing themselves in a difficult position. Almost to the point, quite frankly, that I don't think you want to win this case because there's going to be a bigger fish for your client to fry.
With fair housing?
With the fair housing plan. Because nothing's here. Nothing the landlord is doing. First of all, does the landlord show me any contractual right exists for them to do?
Not that I am aware of. There's nothing in the pet agreement nor nothing in the lease.
At least you have to register now.
Yeah. In this situation, well,
but you're not,
that's
they
not
have
the
to
issue.
register the animal, but we're all in agreement that the animal isn't the issue.
In this situation, no.
Right. It's not the animal. It's her. It's whether or not she needs the emotional support animal. So, and then you're trying to charge her from back when?
October of 23.
Okay, so
This case has been going on a long time.
but this case has only been going on since May for
Yeah.
me anyway. But I don't see it. I just don't. I mean, if somehow or another the landlord were able to say, let me back that up. What really has happened in this tenancy is the tenant has brought forth documents that place her in a certain status, right? Now, the landlord in that instance, as they have to do with many different things, has to have something in place that says, if X happens, if there's a change in status, or that at some point periodically you have to renew with us the fact that you still get the benefit of that status. Or this is how you lose that status. But can you get it back? If the landlord had something in place that said, okay, you get this status, and it's clearly not the case here, but you get this status with this animal. Upon the removal, death, whatever of this animal, then you have to renew your status.
Well, doesn't that
Then,
contradict what you
okay.
just said?
Pardon?
Doesn't that contradict what you just said?
No, I don't think it does. It only seems to contradict it because you're not really certifying the animal.
Exactly.
You're certifying the person. But those were hypothetical situations that I was giving just now,
Okay.
where the landlord could have certain things in place that then would require the tenant to do something, or require at that point, maybe even obligate the landlord to ask that you provide this information or whatever. But here, that's not what's happened. She gains whatever that status and the benefits of that status. There is nothing, I don't think, or nobody's shown me anything that changes that. That's the status she's in. The landlord then can't come along and say, oh, well, now you got to do this. Had the status had everything attached to the pit bull, to the animal, as opposed to the tenant, then I get it, what the landlord's doing. Because now you have a new animal. Now I can ask about that animal. Not what happened here.
Can I ask a consideration? Whichever way you're going to rule, can you make it in a written opinion? Basing it on what you've said in court today?
Well, I would.
In case my client wants to appeal it.
That's fine. I mean, I'll give an oral ruling. You can prepare whatever order you want. You can appeal away because the landlord doesn't have a status here. Or I could rule in favor of the landlord and then let you face the fair housing suit. Do it that way.
Another attorney has to worry about that.
But this issue,
No, I understand what you're saying.
somebody has, well, let me ask this then. Does the landlord have anything that forms the basis of their request to ask this tenant for that second doctor's note?
I'm not aware of it. Are you aware?
Well, as I said, she never did come forth to the office to register the animal. It wasn't until several months after she got rid of the pit bull and she was saw with this other dog. That's when we first made contact with her to register the animal. Here we are today.
Did she register the animal?
Never, no. She has not
But
registered.
the animal isn't the issue.
I understand, but she still hasn't complied with the pet agreement portion. So therefore,
Which portion?
she signed a pet addendum for the pit bull. When the pit bull was removed, she never re-registered the Chihuahua.
Well, you didn't ask her to register the Chihuahua.
Yeah. Well, we did,
No, you didn't. That's not what you asked.
not in this particular case, but
Yeah,
as a
not
side
in,
issue,
you didn't ask her to register the animal.
not for the ESA purposes. But she still has to comply with the lease, which
But if
requires,
that's what we were here for, Mr. Wise, fine, but that's not what we're here for. I
but
mean, I would absolutely agree with you with that previous scenario about the registering of the animal. But this issue is independent of the animal.
right. But would we still have the issue if she registered the Chihuahua? Would she have to reclassify that as her ESA animal? That's one way of looking at it.
What did you ask her to do? But see,
We asked her to
hold on a second,
register.
hold on. No,
Yeah.
because I'm not going to go down that path with you. Because what the landlord hasn't come in about the animal. That's not why we're here.
Well, yes and no.
No, because you're here because of her status.
Well, the case was originally started for non-payment of the pet fee and non-payment of the pet deposit. Was the basis of this particular lawsuit.
Right? But effectively, all of that was suspended in the best light for you, was suspended because she had an ESA and was in need of an ESA. But then at some point, which just doesn't seem to fit into anything logical, she's asked to renew that status. And I think the problem here, even if you had a time period of every 4 years, are there other individuals that you've treated differently regarding that ESA? That's the dangerous.
I knew you were getting to that.
Yeah, because that's the dangerous waters that your client is in right now. And that's what I was saying at the very beginning, because if I rule for your client, I have a feeling they'd appeal, it'd go up, that would come right back to me for a specific finding of was she treated differently? And then your client's got a whole lot of other problems, the least of which is an ESA on this property.
Okay, so basically, if I can paraphrase your thinking, you're dismissing this case.
I'm not. When Mr. Weiss, you know how I am. When I'm ready to do something, I'll tell you what I'm going to do. I don't know. I think as we've gone through this, I don't know that you need me to do it. The right thing to do would be for the plaintiff to dismiss it. And more importantly, then institute and formulate a policy by which you're going to handle these types of situations. Because and part of my reason for saying that is, even if I dismiss, I'm unclear as to this, but I don't know that alleviates the potential jeopardy for your client.
Well,
under fair housing, because it becomes the issue of not always am I successful in what actions I take, that I'm taking certain actions that may be in violation of that and or discriminatory.
Yeah, but if the court would dismiss it, or find no cause of action, let's say. And I would write in an opinion, or not opinion, prepare an order to that effect, setting forth your reasonings for that. That would be could be a basis if my client wishes to appeal. That's all I'm asking.
Oh, yeah. That's what they want to do.
Yeah.
No,
Obviously,
I don't really care, but
no, I understand.
I mean, I think there probably needs to be a discussion for you and your client as to where they're putting themselves.
That's a separate issue.
No, depending on what I do.
But if you dismiss it or find no, this is a hearing on the merits. If you find no cause of action, based.
Well, but Mr. Weiss, I'm going to need to then take some testimony because there's going to be a question in my mind that I would have to resolve as to why this tenant why they made the request of this tenant. And I don't think you want my finding on that.
Can I have a brief recess with
Yeah.
my client?
Or we'll stand in recess.
Good morning. I had a chance to discuss this with my client. At this point in time, we will dismiss the case.
All right.
With one proviso, which doesn't have to be
Of
permitted.
course.
I requested that the dog be registered, not calling it an ESA or not, just that they have to go in the office and register the dog.
But upon registering her
Status is not
stay the
changed.
same. Okay. Ms. Bell,
Sir.
first of all, do you have any objection to the dismissal?
Providing they're gonna leave me alone.
Oh, I didn't ask you that. Do you have any objection to the
I don't
case
have
being?
any objection.
Okay, now, hold on, Miss Bell. You sat there so patiently before, you just wanted to yell at me, didn't you?
No.
All right. So then the next thing is that will you get the dog registered with them? That's not going to change your status, meaning everything's going to be like it is. They just want the dog registered, which probably is appropriate.
But Justice, we had actually given them a letter from Dr. McAvoy months ago.
When I
stating
first got.
stating that the dog that she's supposed to have an emergency.
Hold on. I think that issue's over. Right? So
Well, he's asking me to send him an email from Dr. McAvoy.
I just want,
well, if you look, folks, they're looking to dismiss the case.
Mhm.
They didn't ask me anything about an email. The only thing that they're then asking is that you register the dog. And Miss Bell, you don't have a problem doing that, do you?
No, I can do that again.
Pardon?
I can do it again.
Did you already register the dog?
Yes.
we're not showing you.
You're not showing a register, sir?
I checked it.
Oh,
Okay. Well, whether you did it before or you have to do it,
I'll do
let's
it
get,
again.
you'll get the dog registered.
Yes.
All right. Under those terms.
and the dismissal hearing.
All right. Case
Your
dismissed.
Honor,
Yes, ma'am.
one thing, I just got out of hospital again, and this is my only transportation right here. Cause she's got to go back and forth to the doctor because she was in a car accident. So it's hard for me to get anywhere because I have to go on this.